registered Eternal Women PS case number 35 of 2024 under section 85 of BNS, 2022. Issue notice. Not issue notice. Mr. T at London additional PP appears to the state. No formal notice. So, list of scan copy of the case diary be produced on the next list after 3 weeks.
Oblige, Your Worship.
Yes,
My lord, this is regarding my lord, non-consideration of the appointment despite there's a reservation, my lord,
yes,
the PWD, my lord.
yes.
So matter is very simple, my lord. The 5 posts reserved out of 60 posts, my lord, as for PWD candidate, my lord. Now,
5 posts.
yes, 5 posts. Now the petitioner is qualified in written examination as per advertisement and the guideline, my lord. The minimum, the qualifying marks is 33% in each subject and aggregate 45 marks, qualifying marks. Whosoever cross this 45 marks will be called for interview and considered, my lord. Now here, my lord, the petitioner qualified not only 33, 45, above 45% in the written examination. He has been not been called for interview. And despite the 5 posts, my lord, only 1 post of PWD candidate has been appointed. And the 3 has been appointed for some other general and other APST without considering the petitioner. And 1 post has remained vacant, and there's an interim order, man, for that particular 1 post, my lord. Now here, my lord, just now I've been told, my lord, although it's a very simple matter, but the APCC council, my lord, is expressed this inability.
Your Lordship, I'm praying for next date, Your Lordship, this matter.
What is that? It's very simple.
Your Lordship,
Why she has been rejected? So he
My lord.
has been rejected. Why he was rejected? Why he was rejected?
Your Lordship,
He scored more than 45% in aggregate.
so apart from commissions, there are other parties also, Your Lordship. Private
Okay,
respondents are there.
You are the one who has refused to select
Yes.
him.
In our affidavit, we have stated that the reservation do not starts from the written examinations. It starts at the time of interview, Your Lordship. That stand we have taken in our affidavit.
But if he
So-
is qualified to be called for interview, how many reserve candidate you have called for?
Sir,
Only
Your
one.
Lordship,
How much he scored?
My lord, the person was
Or
appointed,
he was called for interview?
my lord, yes,
46 point.
my lord, in his case, I'll just, my lord,
Can it be
Wow.
on,
Obviously, he'll be above you.
above me, my lord, no doubt, my lord. In PWD, my lord, he's above me, my lord. PWD, that's no doubt because she is appointed against the reserve quota, like, only
See.
5 posts.
See, suppose there are 10 posts.
Yes, ma'am.
For interview, how much it has to be called for? Ratio
Malad-
is what?
30, my lord.
Huh?
30, my lord.
30.
One-
1:3.
My lord,
If you don't fall within this 30,
My
even
lord.
if you are qualified,
my lord.
can you claim?
My lord, that is, my lord.
That would be, I think, their strength.
My lord, that is their stand.
Perhaps.
My lord, so far, my cases, we are PWD candidate, man. Special categories, man. We have to be treated separately. Their statute also it says, and also we have a
So what do
state
you want?
guidelines, man.
Not Mr.
12, my lord. Fixed for hearing on 12.
MS N. Anju, London. Counsel appearing on behalf of Mr. A. Paul, members, standing as a senior counsel. Public standing counsel for the APPSC. express difficulties on behalf of Mr. A. Apang, who is stated to be indisposed today. Mr. She raised for listing the matter on when?
12, your lordship.
12,
12 hours.
12/06.
Eight.
08/20. We'll admit it.
My lord,
It's for hearing.
Yes, madam.
Admit this writ petition. You are appearing for?
3, 4, and 5.
You refer
2, 3, and 4.
Mr. S. Tapin. For respondent number. Learned senior government advocate for respondent number 2,
2, 3, and 4.
2, 3, and 4. What about others?
Other, they were represented by R. Saitya, madam. They appeared.
He informed him that we'll take it upon
Yes, madam.
12.
Obliged.
List the admit this writ petition, list for hearing on 12.
Deeply obliged.
Item number 6. Yes,
My lord, the conducting council, the senior council, he could not take up the matter today due to some personal difficulties, my lord. We are for the petitioner, my lord. The senior council could not take the
see,
matter
this
today.
matter has been listed as per mentioned memo. You have mentioned the matter for listing.
Yes, my lord, but due to
Then yes, what is to be done?
Lordship, I strongly object the submission made by the petitioner. Lordship, it's not the case that I have not accommodated the petitioner. The matter is being pending since 2023 November. The trial is going on before the learned session court. They are abstaining from.
There is no stay.
There is no stay. However, only on anticipating that there will be
Not
some
Mr. So-and-so, learned counsel.
in
for
that
the-
case.
Learned counsel appearing for
R. Sonar, my lord.
Mr. Arson, learned counsel for
My-
the petitioner.
My lord,
Next
But-
para. It is noticed that the letter has been listed on mention being made by whom?
Made by petitioner.
By the petition.
Lordship,
However-
may I just
Mr. So-and-so, learned counsel submits that his senior, Mr. Arsener, has some personal difficulty. Personal difficulty today, for which he prays for listing the matter. On, prays for adjournment of the matter. Mr. Arko, next para, learned counsel for the respondent. Vehemently objected the prayer. Why?
it's not the case that I have the this court may have other view, but then the objection is because I am accommodating them for last 1 year, and now the objection is because the trial is undergoing in before the session
There's
court.
no-
However,
there's
they are
Is there any impediment?
no.
in the
However,
trial.
however, they are abstaining from appearing before the session court.
my lord, because of trial, we are only suffering, my lord. That's why we have filed this petition. We are the suffering, and today, because of personal difficulty, only we are
It's,
sitting at home.
Because on this matter was fixed on 17.
It's okay.
Yes.
No, this, you just right. How about Mr. No, Mr. Arko is vehemently opposed the prayer for adjournment. However, considering that the Mr. Sonar has some personal difficulty today. Come on, let this matter be listed after 2 weeks.
Your Honor, may I pray that the matter may be listed on 12th?
No, my lord, at that time, I think Sonar, senior will be out of station, my lord. Maybe it may be fixed on 20 of this
No,
month.
20, I may not be here. On 26,
2022.
no, on 26, because on 25th, I'll be back.
Considering Shoaib, that this method will be listed on 260820.
Because it was fixed on 26
And-
only
and
earlier. on.
Finally, as ultimately consented by the parties.
Much
Many
of it.
thanks, sir. Keep you.
My lord, I would like to take the shelter of the judgment rendered by Honorable Apex Court in the year
Yes,
2021. Before that, my lord, I will just come to the PEC, my lord,
yes,
because the petitioner want to establish that there is no dispute. Although in the judgment it says if the issue involved is disputed, then 226 will not lie. That is there. But in certain cases, this honorable court is not barred to educate such petition, my lord. If the issue involved is not disputed, that is why on the other day, my lord, I've
they are disputing it that you have not supplied the materials.
that is why, my lord, I would want to show that, show from their own document that it is not disputed. Because they have acknowledged the receipt of the material supplied by me. I have annexed those documents, my lord. Firstly, my lord, kindly come to those documents, my lord. This,
Will dispose it of, you argue,
yes, ma'am.
from beginning.
Yes, my lord. Then in that case, my lord, kindly take up my writ petition, my lord.
Yes,
I am very sorry, my lord, I have forwarded to brought my space, my lord.
somebody lend him some glass.
हो जाएगा. It's okay, my lord, it's okay. I might take extra time, my lord. My lord, the
But I'll
petition,
just give you 10 minutes,
yes, my lord.
not more than that.
Yes, ma'am. Okay. Yes, my lord, this is not disputed that the Saubhagya scheme, the work for Saubhagya was not awarded to me. It was awarded,
I don't know what is
Yeah.
Saubhagya.
Saubhagya is, my lord,
You make your submission from the beginning. What is the fact?
yes, my lord. My lord, there is a scheme for supply of materials,
What material?
uh, supply of this overhead line materials under Saubhagya scheme package number Saubhagya Lower Dibang Valley 02 to the petition farm.
Hmm.
And accordingly, a letter of acceptance was drawn on 24/10/2018. Thereafter, the petitioner entered contract with the government of Arunachal Pradesh for adjudication of the same work, my lord, on 31/10/2018. And the government of AP was represented by executive engineer, electrical division, Rohing, Lower Dibang Valley. That after the acceptance and the agreement was drawn, the petitioner started the work, my lord. The petitioner was paid, after the completion of the work, he was paid 70% of the bill against the 100% in 2 installments, my lord.
Yes.
Now only 35% is left, and the 30% amount comes to 1,27,689. This is the remaining bill amount, my lord. Now, how this remaining bill amount is not being paid, my lord? They are saying that, my lord, I have not supplied 4 items, my lord. That is in their affidavit, my lord.
You first, you from.
Yes.
What is the contract?
Now-
agreement? What is the contract agreement?
Contract, it was to be this completed within 1 year, my lord.
Where it is, contract agreement?
That, my lord, I have not annexed, but my lord, it was to be,
Will be required
yes, my lord, I have annexed, my lord. It is in, annexure 2, my lord.
page
Page number 21.
21.
Yes, this agreement made on 31st day of October 2018 between Department of Power Incorporated under the Indian Electricity Supply Act of 1948, having its registered office at Vidyut Bhavan, Itanagar here in after call, Department of Power, which expression shall include its administrator, successors, executors, and permitted assigns. On the one part, MS Renia Enterprise, a registered firm under Government of Arunachal Pradesh here after.
Where it is?
It is at page number 21, my lord.
21 is something else. Supply contract agreement.
In my writ petition, my lord.
Yes.
Page number, annexure 2, my lord.
Hmm.
My lord is taking up my writ petition, my lord. Writ petition number 196. Page number 21.
This. This one.
No, no, my lord.
This is page 21.
Is it the writ petition, my lord, is holding, my lord?
Yes.
I'm going to compare with my copy, my lord.
Just show him this one.
No, my lord, this is the affidavit filed by registered respondent, my lord. My writ petition, my lord, I will take out the page, my lord.
Okay, affidavit is bigger than your writ petition.
Yes, my lord, yes. Ma'am.
Why there is no running pages here? Who did we do this? कौन करता है?
It's a
Section
signature,
को
my
बुला
lord.
लेने पर एक बार ही बुला लो है ना running page system करके क्यों नहीं सर
Annexure 2, Annexure 2, sir. Annexure 2 नहीं देखो. पता नहीं sir.
your writ petition is consists of sixteen pages.
Yes, my lord.
16 pages.
16
then-
page, my lord.
Yes, page 21, yes.
Yes, 21, my lord.
Is there any arbitration clause?
No, my lord.
Why you are saying no? Page 23.
My lord, my lord. Yes, my lord, please, dear my lord.
Perhaps you are not ready.
Yes, my lord.
List it on 12th
Yes, I had a difficulty, my lord.
for final disposal. There is another judgment of this court, 2024. Read that. You just have to, you don't have to go here and there.
My
You
lord.
just have to- You know, there's no dispute that contract was awarded to you,
Yes, my lord.
right?
Yes, ma'am. Only what they
70%
are,
payment has
what
been
they are, yes, my lord. What-
released,
Yes,
only 30%.
yes, ma'am.
According to them, they said you have not supplied this 30%.
Yes, my lord.
And unless you show some bills or something like of supply,
Yes, my lord.
that
That is what, my lord, I was trying to show this honorable court, my lord.
that's yeah, just you show that.
Then let me show that, my lord, item
You are
which I
not
have
able to
supplied.
say,
Yes, other,
no, then take it up on 12th.
on 12th, my lord.
Are you ready? Are you available on 12th? We'll
Yes.
we'll go by your convenience.
Yes, yes, I am available, my lord. But if that is only the issue, my lord, I can just demonstrate now itself.
No, you see, you also saying that by affidavit, you are saying that it has not been supplied, will not be suffice. You will have to show that he has not supplied, or you have to clearly dispute the issue. I mean, dispute the claim that whether he is entitled or not. Some officer said that he has supplied, and the other officer, new officer said, no, you have not supplied, we are not getting the reports. That will not. Once he can establish that it has been supplied, we may direct you. You also clarify that. But I have seen that you have tried to dispute the thing, saying that 30% you have not, he has not supplied.
On 12,
That's why I said the 10 minutes. It's 10 minutes over.
on 12, my lord.
Yes, sir. On the prayer of learned counsel for the petitioner, release this matter on 12:08 for final disposal.
Item number 9.
It's for submission of that thing on.
Yes, yes, committed.
Take it.
Yes,
Are the learned principle of petitioner. What was the last order? Let me see. Read petition, not I. Matter was, the hearing was concluded on three zero zero seven 2024. On the prayer of learned counsel for the parties, the matter is listed for submission of written argument. The filing of written argument. Parties have submitted their written argument. Reserve.
May it please your lordship. Matter relates to cancellation of GST registration, my lord.
Yes,
My GST was cancelled, my lord.
yes, where is Mr. Kato?
I've informed him last occasion also. Today all morning I've informed, my lord. I'm paying for similar orders, my lord. It is at page 48, my lord.
Huh?
Page 48, my lord. Similar orders are there. My GST was cancelled because of non-filing of returns, my lord. Subsequently, I have updated all my returns. And at page 48, my lord, in a similar situated case, my lord, for directed date on payment of taxes, my GST may be revived, my lord.
Yes,
Well, as per the instruction, yes, this is a similar case, my lord, covered case, my lord.
so you'll have to revoke the cancellation.
My lord.
Have you filed the updated?
Yes, my lord. I have filed, I have annexed also in my
Where
petition,
it
my lord.
is?
It is page 30, my lord.
30.
30, my lord. It starts from page 30, my lord. And it is updated till,
Do you agree to that? He has updated.
My lord.
they can also verify, my lord, from portal. I have updated.
Heard Mr.
RS Mishra, my lord.
R.S. Mr. Learned counsel for the petition, and also heard Mr. M. Kato, learned DSJ for
All respondents.
all the correspondence. Next, by filing this writ application, the petitioner has put to challenge the order. What is the order?
Page 29, my lord.
29,
My lord.
order number so and so, order reference number so and so. That is 02. 05/2023. Passed by the,
Respondent number 4, my lord.
passed by, this is superintendent,
Yes, my lord.
superintendent. What superintendent?
The superintendent central goods and service tax, my lord.
Superintendent, respondent number 4.
4, my lord.
Central goods and superintendent, huh? Comma, central goods and services tax. Return over range. Comma, 0. Weber. The GST registration of the petitioner has been cancelled. On the ground of what?
My lord, non-filing of pending returns, my lord. It is there, my lord, serial number 1, my lord, page 29, my lord.
Ah.
The taxpayers neither submitted reply to SCN dated so and so, nor they filed their pending return till date.
No, as the petitioner has failed to file the return,
My lord,
file the GST return.
GST returns.
For the year,
My lord, the rule says if for continuous 6 months I fail to file the return, they can cancel it, my lord. So for 6 months I defaulted, my lord. It is there, page 28,
the
my lord.
petitioner has failed to file return, the GST.
My lord.
This code. Next paragraph. While issuing notice to the respondents, has directed on 23/07/2024 has directed the DSJ to not directed, has
Actually, short for the instruction, my lord.
has directed to obtain instruction whether the present writ petition is the grievances raised in the present writ petition is covered by the order of the coordinates bench of this court in WPC 6232 of 2022. Next paragraph. Today, Mr. Hemka, learned DSG, in his usual fairness, has submitted that the present issue is fully covered by the order of this court passed in WPC 6232 of 2022. Right? Only one
My lord.
just will
My
remain.
lord.
Next paragraph. The learned counsel for the petitioner submits that petitioner has already filed their up-to-date return and paid the tax amount due along with other statutory due as per rules 22,
My lord, 23, my lord.
23 of the GST rules, 2017. The same has not been disputed
My lord.
by the London DSGA. Next paragraph. Having considered the submissions and considering that the parties have accepted that the grievances raised in this petition is fully covered by the orders of this court dated 29/09/2022, passed in WPC 6232 of 2022, comma. The writ petition is disposed of. By directing the respondents to restore the GST registration of the petitioner forthwith on filing the return along with deposit of the statutory dues by the petitioner in accordance with the rules, applicable rules. The same exercise shall be carried out as expeditiously as possible. Within 50 days, as possible. Mr. Within 10 days from, within 15 days from today, the respondent number three,
4, my lord.
shall intimate the petitioner as regards the outstanding statutory dues, comma, if any, payable by at this payable so as to enable the petitioner to file return and make necessary deposit, comma, if any. The writ petition is then disposed of with the above direction. Yes,
In this case, the accused has been rearrested by the court, trial court.
rearrested.
Yes. Because they are deported, they are not appearing in the case. So when they appear in the court,
Yes.
they are kept in the custody, they are repeatedly not coming in the court.
So what
Kindly
is-
see lordship,
what is to be done?
I have to defend the case. So
Hmm.
I may be released on bail.
No, have you impleted the,
It's complainant.
you have impleted? You have impleted?
Let me see.
But
No,
service
not
report
impleted.
regarding submit report, there is no file, nothing.
Yes, where,
Yes,
where
impleted,
this file not-
impleted.
Yes, you have impleted,
Yes, respondent impleted.
but then there's no service report.
Awaited service report.
No, there's no noting.
Yes, that means
Why-
it's awaited, still awaited.
You have filed the IA.
No, I have been directed to this. Yes, written in the,
There's no office
Application.
note, whether notice. Have you taken steps?
yes, I have taken a step on it.
There's- Uh, 27 only. 22. Notice was issued on 22, 23 only.
I'm not aware of the record.
Next, Mr. Tita, will you wait for some time?
Yes.
It was issued on July, 23rd July.
Yes.
And Mr. Tita, Learned Counsel for the petition. As for office note, dated 03/08/2024. The scanned copy of case records from Special Judge within bracket, Foxo, Bombilla is received. Full stop. However, no, the notice was issued on 23/7/2024 by registered post AD to the respondent number 2. No, there is no office note in this regard. List the matter after 2 weeks.
After 1 week.
We will see, 23rd, today is what, 5th only, not even 2 weeks, we'll make it 2 weeks. 2 weeks, registry to verify. And list the matter after 2 weeks. 12, 11, 12, 13.
Same matter.
Yes, 11, 12, 13. Number 14. Yes.
Lordship, is an application under section 439 of CRPC.
Yes,
So FIR is on page number 17, Lordship.
yes. Who appears for the state?
Okay, was there, Lordship. Lordship, the alleged accused person was arrested on 4th of the June 2024 in connection to Naharlagan PS case number 5524 under section 20.
I know a lot of people, he is outside.
Why? Yes, after some.
That's good.
Item number 15.
So we are, appeal for the IO. Security and bail bond executed.
This is what?
AD
Yes, but under which section?
460 and 471, forgery.
Why respondent number 2 is a party?
My lordship, mistakenly is there is party. Otherwise, it's not.
AD card not yet received in respect of respondent number 2.
Otherwise, the complainant is not necessary party, my lord.
Why you were mad in that case?
Can we track of my lord?
Yes, who appears for? PP. 15.
Last occasion, Lakshmi was there.
We'll wait for them.
No,
Yes,
CD, yes.
yes.
We have received the CD, Lordship.
You have received the CD.
Lordship.
Is there anything?
Lordship, his statement is recorded, Lordship, and the main accused, Lordship, who has issued the fake license, Lordship, he has been served notice under 141A, Lordship.
Which benefit?
Lordship, from whom he has received that fake arm license, Lordship. His statement is recorded, Lordship.
What did he say?
As per his statement, Lordship, he is unaware that the license is fake,
He's
Lordship.
not aware.
Not, Lordship.
Who has given him the, from where you have obtained the license?
The person, one person is there. I have lodged FIR against him also, my lord. He provide me a gun license, my lord. And he told me that
How can a person, who is that person?
that person, yes, my lord. It's
License is to be by the deputy commissioner.
deputy commissioner, and he says he will obtain the license by obtaining necessary documents from me.
The weapon has been seized.
No weapon was purchased, my lord.
You have not
And
purchased.
yes, in strength of this license, my lord.
And this is the person, Lordship, the accused person, is served notice, Lordship.
It's okay. What about you have got the license from this man?
Yes.
Or Loham?
Yes,
Noram.
yes. And last page, I have lodged a FIR against him also, my lord.
It's okay. Where is his statement?
Lordship, I have flagged, Lordship. Let's mark it. One is, Lordship, informant statement, and another is his statement.
Pahitara.
Lordship.
Yes, we'll make the,
No.
or Mr. K. Tariq, then counsel for the applicant by filing this application under section 438 CRPC. The applicant has prayed for grant of the privilege of pre-arrest bail to the applicant in connection with coloring PS case number 210 of 2024 and section 468 of the 471 of IPC. This was filed before the coming into the force of new act.
No, yes, before coming into force of the new agreement.
Where's the FIR?
FIR is best, my lord. There's 10, my lord. 10 onwards, my lord. Yes.
What one words?
10 is the letter forwarded to the officer in charge by the, my lord, say, CO. Superintendent of Police, my lord, SP, my lord. SP. CO has lodged a complaint before the SP, my lord. My lord will find that page 13, my lord. 1 3, my lord. Then accordingly, SP forwarded them to the officer in charge, my lord.
Next paragraph. The case as arisen on filing of FIR, filing of an FIR dated 07/06/2024 by one C.W. Manpur, circle officer within bracket J, bracket close, before the superintendent of police Kurung Kume district, Koloriang, stating that the office has received an arm license number KKD oblique, all capital, KKD, page 13, oblique, capital A, oblique 262, with license holder Sri Techi Pohu, Taru or Tara?
Tara.
It is Taru,
Yes, it's wrong there.
Tara, son of late Techi Tajip Tara, village Gumte, POPS Pakke Kese, district Pakke Kese, for renewal. Mr. However, after proper scrutiny of the arm license and the official record, there is no such arm license. Mr. No registered, no such arm license, no registered, nor issued from the office, and therefore can be safely concluded that the arm license is fake.
Lordship, this is registered, Lordship, under 468 and 461 IPC, Lordship, 471 IPC,
Yes, what I've said.
Lordship. No, Lordship, that's why I'm applying this. code.
Did I say something else?
No, Lordship, I thought I'm licensed. I told you.
The Mr. Pursuant to the pursuant thereto, continue, The case has been registered. The case was registered on 11/06/2024.
Yes,
10 by law, 10 June.
11.
Register on 11, yes, 11.
Registered on 11/06/2024. Being following PS case, So and so, following PS case. Number 210 of 2024 under section 460 and 471 of IPC, 1860. Then what happened thereafter?
Then I approached this court by filing this AV. Then On 18th June, the
No,
AB was-
Mr. K. Tariq, learned counsel for the petitioner, submits that when the applicant visited the office of the Deputy Commissioner Kurungkume District,
yes, ma'am.
for the renewal of his arm license, which was obtained from the one city Tarlora.
Yes.
He found that on the information revealed to him that the arm license is fake, as there is no registration of the said arm license. The applicant immediately contacted the one city Tarlora, from whom he has obtained the arm license, but by paying certain amounts. They said Tarlora has assured that same shall be settled. Mr. However, there was no settlement as issued by the said Tarlora, and the police has already registered the case. Have you been summoned? I mean,
No, no, madam. I didn't summon.
issued, is already registered the case on the basis of the said like has already registered the case on the said arm license being fake. From the petitioner apprehends that he may be arrested by the police. Next paragraph. Mr. K. Tariq, learned counsel for the petitioner. The applicant submits that the applicant has also filed an FR against the said Tarloram, na?
Yes, ma'am.
Tarloram. Before the Colonial Police Station, before the officer in charge, Colonial Police Station. What happened to this? Has it been clubbed together?
No, so because there's zero FIL lawsuit, this is after the lodging of the FIL lawsuit.
Okay. Next paragraph. This court will issue notice on 18/06/2022 as granted interim pre-arrest bill to the applicant. Mr. MS L. Hage, learned counsel for the learned additional PP. Has placed the case diary. She submits that it appears that the fake license was manufactured by one city Tarloram of Papua, Naharlagan. And thereafter was issued, was given to the applicant, the present applicant. A notice under section 51. A of CRPC has already been issued to the said third Lora. So he has appeared, not appeared,
Not yet, Lordship.
huh?
Not yet, Lordship.
And he is yet to be appeared before the investigating officer. I have considered the submissions of the land council.
Lordship, we have received this CD, case study on 10th of July, Lordship. And today is, Lordship, 4th of August. By the time, Lordship, he may be appeared, Lordship. I have no idea, Lordship.
Whatever information you have.
Yes, sir.
Then before that, huh? Considering the materials and the materials in the case, come on, see, fairly submits that. See, you have no objection.
Lordship, as per the Lordship case study, Lordship,
Yes.
there's objection was not.
She has no objection as such to the bail application.
Lordship. Because his
Provided
statement.
the applicants
Lordship.
cooperate with the
Investigation.
investigation officer. Then I have some considered the submission of the counsel for the parties and also paying the case that having considered that the and having considered that the investigations reveals that the fake armed license was issued, armed license was given by one said third Lora, who is said to be the main accused, to the applicant, to the applicant. And also considering that the petitioner appears to be prima facie innocent in the matter. Although he ought to have verified before accepting such a license. Some of the considered view that the petitioner is entitled to the privilege of pre-arrest bail. Accordingly, the interim bail granted by this court on 18/06/2024 is made absolute with the same terms and conditions. Bail petitioner is then disposed.
I apologize, Your Lordship. I was
Yes.
not present there, sir.
Yes.
Lordship, this is an application under section 439 of CRPC regarding granting of bail to the alleged accused person.
Yes.
In connection to the Naharlagan PS case number 55/2024 under
Yes.
section 21B 2527 of NDPX.
Yes.
So FIR is in case number Lordship 17 that is lodged by officer in charge Naharlagan Police Station K. Dev. Allegation is that your Lordship. May I read out? With due regard, I am submitting the below mentioned line for your kind consideration, please. On 2/05/24 around 13 hours, a verbal information was received from a reliable source that one person named Miss Anureba is in possession of heroin and is selling it off from the residence of one Mr. Joram Taluk in Delhi market near Helipid, Naharlagan. The source further stated that if not apprehended at the earliest, he might flee after disposing of the heroin. The said message was conveyed into writing and entered into general diary, and after SP Capital and SDPO Naharlagan conveyed about the same, and they gave verbal approval to conduct the raid. Further, SP Capital was also intimated by the written message as well as accordingly a team lead by undersigned left for the said spot along with seizure, packing, weighing and selling item as mandated by NDPS Act, accompanied by ESC Naharlagan Sri Kodabad APCS to team lead by undersigned ESC Nahar arrived at the house located at Delhi Market, Naharlagan, Helipid, as shown by the source at 1340 hours, and surrounded the said house and asked to open the door, and we entered after our personal search is being carried out. The room of the said Sri Joram Taluk was knocked, and he opened the room. He was asked to come out of the room. After they came out, they were informed that police team suspect that he is in possession of drug and needs to search him and him and the house. They were also informed that they have the right to be searched, inform gazetted officer, but they were refused to avail the right. Prior to their personal search, police team searched ourselves in presence of the witnesses, and nothing adverse was found on ourselves. Upon being entered, we found 3 girls, namely Anuraba, Pedlar, Tali Nini Kamdir, and Golo Kuku, both addicted youth and male, a male person, namely Joram Taluk, who is the owner of the house. All of them have been placed in a corner of the room. Person, namely Sir Joram Taluk, who is the owner of the house. All of them have been placed in corner of the room, separating the male person, and conducted search operation. During house search, 17 plastic bags containing suspected contraband drugs, drug heroin, weighing 25 grams found inside the handbag, light green in the color toy, and used syringe, soap, poisoned case, rupees 3,510 recovered and seized according in presence of executive magistrate. The said bag was kept on the mosquito net. Later, it was confirmed that the said bag belongs to Ms. Anureba, who brought the recovered contraband drugs from Assam on a forge and had filed the said contraband drug from the forge to plastic vials at the house of Sri Joram Taluk in order to sell it separately to the addicted youth. The said recovered item was packed and sealed in the presence of witness and would be produced before the learned magistrate for sampling and preparation on inventory under Section 52A NDPS Act. All the detained persons were brought at PS with recovered item for further proceeding as per NDPS Act. The seized item have been packed and sealed from the spot, handed over to your good office by NLGP SMR number 55/24 for further production before the learned court. Given the above fact and circumstances, that the said person, Ms. Anuraba, is obtaining heroin from outside the estate, and they sell it up to the youth of ICR, destroying their future. Mr. Joram Taluk is alone his house for such activity. Lordship, on the basis of that, police has registered this case under Section 21B 25 of 27 NDPS. So in this case, Lordship, what happened? This my present alleged accused person is nowhere involved in this case. His name is also not been mentioned in this FIR. So all this person has been arrested by police on that day itself. So the present alleged accused person was arrested by police on 3rd of June 2024. On the basis of Lordship Anureba, that's alleged that the present alleged accused person is the drug seller. Not Your Honor, Lordship, but what happened? Police has nothing recovered from the possession of the present alleged accused person. So arrest memo is in page number, Lordship, 18. Lordship. So this alleged accused person is, Lordship, is just a simple auto driver by profession, Lordship. So what happened, Lordship?
The simple auto driver may not be involved.
Lordship, but thing is that Lordship, police has nothing recovered. Despite of trolley investigation and trolley, nothing has recovered.
Not necessary.
So only police has arrested on the basis of the four accused person, that is Anuriva.
Main accused.
She has taken the name of this accused person. On the basis of that, police has arrested. But thing is that, Lordship, this alleged accused person is professionally auto driver. Lordship. It belongs to the port.
They are more dangerous.
But Lordship, unnecessary, without the report ending from the.
Yes.
Your Lordship, before going into the merit of the case, it is my duty to advise this court that, Your Lordship, it is more than 60 days now, Your Lordship, and the mandatory period would be 60 days. Because the offense prescribed under NDPS Act, the punishment is extended to 10 years. And Your Lordship, so far as Rakesh Paul Kumar case is concerned, Your Lordship, it will be 60 days if it is governed by the old code, Your Lordship. Charge sheet is not filed, Your Lordship. I am not on merit. Otherwise, so far as merit is concerned, there is a material and he has admitted, Your Lordship.
In connection to
court.
that, Lordship,
Because of the default.
Yes, Your Lordship.
provision.
Yes, Your Lordship.
Is entitled.
Yes, Your Lordship.
Lordship, one of four accused person, that's.
I've said it. The same thing,
Yes,
Yes, Your Lordship.
exactly.
because of 167.
Till today, 63 days.
60 days now.
62 complete, 63 is running, midnight it will.
Which is requirement is 60 days.
Today 63 is running, 62 days already expired, Your Lordship.
No, that's what I'm saying.
Yes, 60 completed, yeah. Because, Your Lordship, the offense prescribed is, the offense is more than small and less than commercial. Punishment is extended to 10 years, Your Lordship.
This present section.
167 of the CRPC, Your
No,
Lordship.
it's okay, but then this is what? Section is
21B, Your Lordship, 25, 27 and 29. 27A is not there. If A is inserted, then
okay.
situation would have been different, Your, because otherwise.
60 days.
Yes,
In
Your
that
Lordship.
case.
Yes, Your Lordship.
Oh, no, there's no way out that case. He
Yes,
may be
sir.
involved.
Yes,
He
Your
may be involved. If he has a right to default, well, what can we?
Yes, that's the reason I'm not submitting on merit, Your Lordship.
But otherwise, he has admitted.
Yes, Your Lordship. Otherwise, he is involved in peddling, Your Lordship. 27A is attracted, but unfortunately, it has not been inserted, Your Lordship.
What is the problem? We cannot correct it now.
Your Lordship, the IO can do it, Your Lordship.
Bail jurisdiction, we cannot correct it.
No, we cannot correct it, Your Lordship.
But these are the problems. You'll have to.
Yes, we have to apprise the concerned IO, Your Lordship,
Yes.
because if the section is attracted, they can well.
If he's involved,
Yes,
I mean, just because of default bail, we're helpless also.
yes, Your Lordship. This is.
Yes, heard Mr. T. Topu, learned counsel for the petitioner. And also heard Mr. T. at the learned additional people for the state. By filing this application under section 439 of CRPC, 1973. The petitioner has prayed for release of the accused person, release of accused person for grant of bail to the accused person, namely Sri Imanul Hujur,
Yes.
who was arrested on when?
Arrested on Lordship,
13,
3rd of the June,
03/06/2024,
And remanded on 4/6, because it will be from date of remand, Your Lordship.
and remanded on,
4/6/24.
it's okay, will not say,
Yes, sir.
arrested on 03/06/2024. In connection with, no, before that, I was there, before that, in connection with Naharlagan PS case,
55-25.
55 of 2024 under section 21 within bracket small bracket close 25, 27, 20 of NDPS Act. Next paragraph. The case has arisen from the FIR, FIR filed by the, where it is, FIR
Page number 17.
17,
Annexure 1.
filed by Inspector K. Dev. Comma, OC, comma, PS case number. No, OCPS, OC, police, OC, officer in charge, police station, Naharlagan. To the effect that on 22/05/2024. Comma, through the reliable sources, comma, an information was received that one MS Anuriba is in possession of heroin and selling it off at the residence of Joram Taluk helipad, Joram Taluk, comma, helipad area, comma, Naharlagan. It is stated that if they said MS Anuriba is not apprehended, comma, she might flee. The police team and the magistrate conducted raid and found 3 girls having addicted to the drugs along with Joram Taluk. The police has also seized heroin and plastic vials from them. Next. Pursuant to the said FIR, the police has registered a case being Naharlagan PS case number 55 of 2024 under section so-and-so said, page 2 in this thing. Next paragraph. The police had arrested the 3 girls and 1 city Joram Taluk from the helipad area. On they were arrested on
4/6.
no these
They were
persons
arrested on the lordship same day, that is on FR the 22.
No, other.
others
Yes,
Yeah, others, yes, 22, your lordship.
22.
22/05
Yeah.
06
22/05.
okay.
It's there in the bail order, 22/05, your
Itself,
lordship.
they read and arrested. FR also was in same day.
The accused, the other co-accused persons were arrested on 02/05/2024.
22.
Right.
not 0,
22nd, your lordship. Your lordship may kindly come to page number 29, your lordship.
29.
22.
The order passed by this honorable court, your lordship.
05/2024.
22/05/2024. lordship. Day of FR as well.
That's what I'm saying.
02, your lordship, 0. Okay.
These persons were arrested.
Yes, your lordship.
Other co-accused were arrested on
5/24. Yes, your lordship.
Yes, 22/05/2024. Same day when the FIR was launched.
Yes, your
Yes.
lordship.
Next paragraph. The accused, the present accused was arrested on 03/06/2024. Next paragraph. Mr. T. Topu Lami, counsel for the petitioner, submits that the accused has been arrested on mere suspicion that too on the disclosure made by one MS Anureba, who is the main accused and alleged to be selling contraband drugs to the youth, drugs to the youth in the capital region. He submits this. Petitioner is neither a drug seller nor drug addict. And not petitioner, accused, huh? Accused is neither involved in peddling in drugs nor addicted person. It is only on the basis of the statement by the co-accused, by one accused, MS Anuriba, the accused has been arrested on mere suspicion. He submits that the petitioner is a auto rickshaw driver. He has no connection with the allegation of either the drug peddling or drug consumption, and its consumption. Therefore, next minute, Mr. So-and-so Learning Council further submits that about the mandatory period of 60 days,
167 and
167 days.
yeah, 60 days, sorry, your lordship, 60 days.
160 days is over.
The statutory
As the
period provided,
petitioner was arrested on 03/06/2024. The police has, the investigating authority has not filed any charge sheet
yes,
within the mandatory period of 60 days.
60 days.
Mr. Therefore, he submits that the he submits that the petitioner is entitled for not only on merit but also on the principle of default bail under 167 of under section 167 of CRPC.
Yes.
And as such, he may be the accused person be released on bail. Next period. Mr. T. Learned additional PP. You have the case diary.
Yes, I have the case.
Let's produce the case diary. Next period. He submits that on merit their incriminating materials against the petitioner. Mr. And then against the accused. Mr. The present accused has admitted in his statement in his admitted his involvement
Yeah, involvement, peddling the,
in the present case, involvement in peddling drugs in the present case.
yes,
However, he has clearly submits that he could not have any objection for grant of bail to the accused, present accused at this stage, as the petitioner was arrested on 03/06/2024 and has been in judicial custody for more than 62 days.
the 60, more than 62 days.
62 days without having been the charge sheet being, without having been, without the charge sheet having been laid by the investigating authority. He submits them in the facts and circumstances. He submits that in view of the mandatory provision under section 167 of CRPC, the petitioner, though on merit, would not be entitled for bail because of his privacy involvement. He is not with the accused is entitled to be entitled under the principle of default bail. Next slide. I have considered the submission of learned counsel for the parties and also paid the case diary. Next. On consideration of the materials, it primarily discloses the involvement of the petitioner, involvement of the accused, namely so-and-so, in peddling of drugs in the present case. However, considering the right of accused to be released on default bail under section 167 CRPC, this court, even if reluctant, has no option but to allow the accused to be released on bail, as he is entitled to the principle of default bail under. It's a principle of default bail.
Yes, Your Honor, indefeasible right.
Principle of default bail under section 176 of CRPC. As the petitioner has an indefeasible right to be
Indefeasible.
released. Mr. Next, but having considered above, the having considered above, the accused, namely so-and-so, is entitled to be released on bail. Accordingly, the petitioner, the accused, namely so-and-so, is allowed to go on bail in connection with the Naharlagan PS case so-and-so, and the section so-and-so. The accused so-and-so is accordingly granted regular bail. The first there is bail. The same bail bond with a bail bond of rupees 20,000 with one security like amount.
Your Lordship, same may be executed within a week, Your Lordship, from today.
Security of like amount to the satisfaction of the special judge
Special judge, Your
in
Lordship.
NDPS from UP. Within
Within 1 week, Your Lordship, from
within
today.
1 week. Any other condition? No.
No, Your Lordship.
Expect. The bail equivalent stands allowed and disposed of.
Your Lordship, I would like to apprise this honorable court, Your Lordship. I have not seen the death, Your Lordship.
as earlier occasion, your lordship has deferred the judgment. So your lordship, now even this application was filed after 1st of July, your lordship. I've just seen it, your lordship.
1st of July.
Yes. Now, your lordship, the issue, what I'm trying to, your lordship, pointing, your lordship, if BNSS would apply in this case, then under 167 corresponding section will apply, then it would be 90 days, your lordship. These are the difficulty, your lordship, which will come up here.
You could have pointed out earlier.
But
We spent considerable time. But since I have not signed, because the same view that will be taken up on 7th,
yes, your lordship.
we'll just defer it for some time. We'll just, you are entitled, let us see. And I'm sorry for that.
I've
You
just,
could have
I've
pointed
just
out.
seen, I've just seen it, your lordship. Otherwise,
When did you file this application?
1 week back.
because the
I'm yet to, this court is yet to determine. I may agree with the coordinate bench also, but then as on that, I have some privacy.
is because
Tentatively, I have some, I have a different view. Other than the.
because your lordship, if this
with
matter,
Respectful,
if this aspect is also considered together, then it will be better for this honorable court to.
you just type it out, list this matter, we'll see. Next para. Sorry, we'll take it up day after tomorrow. After dictating the order, it is pointed out by the land council parties that this bail application has been filed under section 439 of CRPC over 1973 within bracket, now repealed, after coming into force of the
BNSS.
BNSS 2023. This court in connected other matters has fixed the matter for the further consideration with regard to the maintainability of the applications under the old act. If the offense, if the FIR or the offense, if the FIR has been registered prior to the
Implementation of new Sanhita.
coming into force of so-and-so. That is I 010720. Mr. Therefore, this court is of the view that this matter may also be listed along with this matter may be listed on 0707 08/2024 for further consideration. All right, we'll see.
Obliged, your lordship. But
We'll
we'll
just type it out. We'll keep it.
but we will return the case there, your lordship. In the,
I keep it.
okay, your lordship. Obliged.
Yes. What is to be done today?
Petitioner is absent.
Who is for the petitioner? Yes. You are for the petitioner?
No.
No, he's with you.
Yeah.
Okay.
Supposed to
What is the
be,
matter, sir?
Petitioner is supposed to.
no, we withdraw the case.
Huh?
The petitioner is supposed to withdraw the case as per the earlier order.
Wakalat Nama has been filed on behalf of the petitioner. And the same is placed. Who is this? Who has filed this Wakalat Nama?
Earlier, he filed for only one petitioner, Your Lordship. So the court has
Yes.
directed to file for both the petitions.
Okay. You are for respondent.
Respondent,
Yes, where is this?
567.
Wakalat Nama? Huh? A. Saring.
Yes.
Where is A. Saring?
he has also already withdrawn his
New council,
Who is the counsel?
Nabam Tanya.
withdraw this petition. What is to be done?
My only prayer is that let the matter be dismissed. Because then they are not interested to participate in the case.
Problem is that this N. Tanya has signed on behalf of petition number 1 only, not the petition number 2. The earlier council has to issue a notice. Has it been?
Yes.
Who is the Tanya? He's not around. It's irresponsible. We'll take after some time. Can you find him out? Or make a call, find out after some time. Yes,
Service is still awaited, Your Worship.
not overtaken,
Yes.
completed. Yes. You are for?
I am for responding.
One. Two is also returned back. On MS?
D. Riba.
For appellant, then counsel for the appellant, Mr.
I'm appearing on behalf of Mr. T. Taeng.
T.
Taeng.
Appearing on behalf of Mr. Chich. Mr. El Perme appears for respond number 1. Next para. Office note that is 170724 reflects that service of notice and the ID card in respect of respondent country has been received back after serving after causing service. Mr. Expert. In view of the service of notice in respect of respondent number 2 is complete. This for admission hearing after 2 weeks.
Your Honor, we just received a copy of the affidavit filed by the respondent number 1.
Yes.
So we may be given some time to file our
How
affidavit.
many
reply.
respondent?
There are 2 respondents, Your Honor.
Okay. All
Lo-
appear, all.
Lordship,
You are representing all the,
yes, respondent number 1 for Gaungro.
I am respondent number 2.
okay.
So Lordship, it's almost this matter, both the party has mutually settled there in customary court. And same is also actually that is also served them in the month of February only. But that has been going on. So it's all,
If they will settle, what's there?
and even apart from that, this CRP,
Do you have
Yeah.
any,
We have not received any clear instruction from the client. That's
Okay.
Lordship, it's a
Just give us some
CRP that
okay, we'll give him some time.
Yes, Your Honor.
Heard Mr.
Mukbang Pertin. MUKB.
Learned Counsel for Deputation. Mr.
T keeper, T Tanya
Okay,
keeper.
so and so, huh? Learned counsels appears for the S1 number 1 and 2. Submits that. Matter has already been settled.
Yes, based on the customary judgment is also their consent judgment.
Is it settled?
Yes, it's settled.
Amicably settled.
Yes, amicably settled.
Has already been amicably settled between the parties or amongst the parties. How many parties are there?
There are 2 parties only.
Between the parties, Mr. Pertin, and counsel petition, however, submits that he has no instruction to that effect. And you have received
We just received it today, just now.
that is your affidavit.
Affidavit.
And he has received a copy of the affidavit filed on behalf of respondent one.
One, as status report of this settlement.
Which reflects the amicable settlement between the parties. He phrased that sometime may be granted to obtain instruction.
Much obliged,
Just after 2 weeks.
Much obliged.
Highly obliged, Lordship.
Yes, who appears for 1 and 2?
One, service report, my lord. Is
Just wait. What about 1?
one to my lord, we have taken step, my lord. On both, to both, my lord, 1 and 2, my lord.
No, 1, 2 in respect of respondent number 2. Edgar received back after service of notice.
My lord,
But 1, it's on February,
my lord.
return answer. You have not taken place steps.
Yeah. Then I will go for precious step, my lord. Otherwise, my lord, this was, then
counsel for the petitioner. Office note dated 03/08/24 reflects 2024 reflects that service ID card has been received back after calling service on respondent number 2. Just however, there is no office note showing the status of the respondent number 1. Showing the status of service of notice on the respondent number 2. Except the service report the office note dated 08/02/2024. Next paragraph. In view of above, the service in respect of respondent number 2 is complete. The next paragraph. However, the learned counsel for the petitioner, not however, the learned counsel for the petitioner take fresh steps for service of notice upon respondent number 2. One within 2 days,
Oh,
3 days.
interim, my lord, is dated.
Interim order, there was shall continue. Yes, next.
Made to Joseph Mara, this is regarding
No
land
press steps.
compensation matter.
No press steps, to take press. How many days? 3 days. For 3, 7 and 8.
Yes, sir.
What is the matter?
Regarding land compensation matter.
Okay. Office note dated 03/08/24 reflects that the petitioner has not taken press steps for service of notice upon respondents number 3, 7 and 8. And consequent, the petitioner is granted 3 days time to take press steps upon respondent number 3, 7 and 8. Within 3 days, sir, have you filed the MS?
No, my lord.
In the meantime, MS T1 learned state council may file their affidavit.
Of pleasure.
Mr. So-and-so appears for responding 2 and 6. What is this?
Well, this IA is trying for condemnation of delay
Hmm?
of 681 days for filing appeal against the judgment and conviction order dated 30/12/2021 passed by the district and session judge Pasigar.
So, this is first time, this is for the first time.
No, my lord. This IA is supposed to be.
Yes.
My lord, I am appearing on behalf of the legal aids for respondent number 2. I am appearing for the first time, my lord. So far, my lord, I is concerned, my lord, just honestly, my lord, I submit that I am not ready to place the argument, technical argument to defeat the condemnation, my lord.
Hmm.
From my side, my lord, I have no objection, my lord, even
Okay.
if it is
Then-
confident, my lord.
Any private respondent, any
I am for respondent number 2,
two,
my lord,
so you have no objection?
my lord.
I'm correct.
Yes. Any?
Yes, Your Worship. 600. $681 days is very long period.
Okay.
Technically, in condonation of delay applications, each and every day delay has to be explained. Here only 3 grounds taken. First, before conviction, his wife was left him. Second, his father is ill. And thirdly, he was not aware of the legal proceedings. It is more than 2 years. In our state, there is a legal service authority who sent a legal aid council in the jail periodically for awareness of legal rights to be given to the inmates.
Condone it, is that it's, appeal is a right,
Yes, appeal is right, Mr.
or Mr.
Obliged.
See, Modi, learned counsel to the petitioner, applicant. Applicant accused,
Yes.
applicant appellant. Would say appellant, it's a applicant only. By filing this application under section 5 of the Limitation Act, 1963, the applicant has prayed for condonation of delay of 681 days in filing connected appeal against the judgment and conviction order dated 30/12/2021 passed by the district and session judge, Pasigar, in PSG SESS case number 05 of 2015 in connection with Inkyong PS case number not in connection, corresponding to Inkyong PS case number 23 of 2015 under section 276 within bracket 2, bracket close, bracket F, bracket close, public 506 of IPC, read with section 4 of POCSO Act, whereby the petitioner, the applicant has been convicted,
Yes, ma'am.
and sentenced to where it is,
7 years.
Page number 13.
30,
13.
13.
Yes, ma'am.
What's the part? Sentence part? Convicted, sentenced to, convicted and sentenced to.
Page number 56. 56. Paragraph number 7 and 8.
Rigorous imprisonment for 7 years. for an offense under section 372 F, within bracket, I think, and to pay fine of rupees 500. No, that is, it's okay. You will delete the last one, huh? Where is the grounds?
My grounds in page number 8 of my application.
Hmm.
Page number 8. From page number 8 to
Oh, no. Grounds for contradiction of delay. You're the.
yes, madam, in paragraph 10. Paragraph 10 of
Where is the, no, 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 where is the grounds? Of delay in filing the present application. On consideration. And having, on consideration. Not we put that, the learned concept for the respondents. Come on. In fact, have no technical objection, as the appeal is an statutory right of the applicant. However, Mr. Jitaro learned an additional critique, which that the applicant has failed to explain each day of delay in the present application. Next one. Then where is the grounds of delay as narrated in the application? On consideration of the grounds and the submissions of learned counsel for the parties. This court is satisfied that the cause which has been solved in this application it is to be genuine, which has prevented the petitioner, the applicant from filing the connected appeal within a period of limitation. Having considered above, come on, this this code, I'm having considered above the present application is allowed. Accordingly, the delay of 600 days, 681 days in filing the connected appeal against the judgment and conviction Judgment in order dated 30/12/2021 passed by the learned district judge, district and session judge. Pasigar in PSG session case number 05 of 2015 is condoned. IA states disposal, allowed and disposal. That's all. List the appeal for admission. List the matter for admission. It's already numbered.
Yes, Madam, this
Is it already numbered?
already number, it's appeal number 2.
Normally in principal sheet, unless delay is condoned, it is not number, only filing number is given. Anyway, the in view of the so-and-so, first in IA number so-and-so, the appeal, the criminal appeal so-and-so be listed for admission. Yes.
Number 16.
Yes.
We received the telephonic phone and also discussed with the Mr.
Hadia.
Nawadanya. He's on disposed condition,
Huh?
indisposed condition,
Okay,
medically.
okay.
He told us he metal may fix on 18 of this month.
Then that's I will say after 2 weeks.
18, my lord,
18,
18, my lord.
Non appears
As a
for
last
the
chance,
petitioners.
as a
on
last
call.
chance.
And Mr. Tishan, Mr. Tishan, Mr. G. Arbasar, London State Council, and Mr. Tishan, London Council for respond number 6 and 7.
5, 6, 7.
5, 6, and 7 are present. List after 2 weeks.
On 18, Your Lordship, will be there.
On what's the urgency?
That will be, I think, at any time they may withdraw the case.
This is the matter also, answer. After 2 weeks, on this is the matter. After 2 weeks on 18.
Okay.
18/08/2020. 22.
I think number 22.
May I please, Lordship?
Yes.
Lordship, here, service report in respect of 1 to 7 and 9 to 14 is completed, but only in respect of 8 are still available.
Okay. I heard Mr. K. Leonard, concept of the petition. Service in respect of respondent number 1 to 7, 9,
9
and 9 to 14
yes, Lord.
is complete. Mr. Award service report in respect of respondent number 8. This after 3 weeks.
With an interim order.
Interim order passed earlier and continue.
Deeply obliged.
I think number 28.
You wanna pass over the matter?
Yes.
Matter may be passed over for a while.
Steps have been taken. Service are already
It's
completed.
listed for hearing.
Yes, Your Lordship.
Hmm.
After 1 week, Your Lordship.
No, it's already listed for
Oh,
hearing.
yes, Your Lordship.
Huh?
It's listed for hearing.
Yes. Who appears for the respondent?
Respondents, they have never appeared, Your Lordship. This is the problem. Now we have sent the notice also.
What is the matter?
It is a matter, title, so then dispute matter between two villages.
We'll hear you at 2. 2.
I think number 29.
This appeal is preferred against the order and judgment of Pasigat dated on 4/1/2024 in Pasigat SC case number 9/2021 under section 354A subsection 2 IPC read with aid of POCSO Act. Now, here in the case, the prosecution has examined seven witnesses and defense has examined three defense witnesses.
Three years.
3 years.
Why 3 years?
Yes, as per section 8.
Under section 8 of POCSO Act,
POCSO Act.
3 years.
3 years.
Okay.
Now, FIR was launched. That is page 2 to 7.
Paper book.
No, paper book 2 to 7.
Where is 227?
Page 2 to 7 FIR. There is one FIR. FIR against one civil Toli Paler.
Page 1.
Page 1.
Yes.
Yes, why you are saying 227?
As per index, as per paper book index, it is written FIR 227.
Yes.
Now, FIR against one Sri Toli Pale, a IRBN personnel of Patigar, with regards to the molestation of my underage daughter, Miss Karina Busi of village Silon, Tio Kanku, PS Mikavali. With due respect, I am to state that my daughter, Miss Karina Busi, who is 8 years old, is staying with her mother.
Why? Why?
You know, I have to file application under 167 for default bail in session court.
Is it?
Yes.
14, this has been, dictation has been. You want to withdraw?
Yes.
Where is Topu?
He already
Papa
went.
Topu.
He already went. You know. He already went to home. You know. He instructed me to withdraw. You know.
Mr. Your name, please?
El Kagong.
El Kagu, learned counsel by the petitioner. Praise for withdrawal of this bail application. Please to praise the Lord. Bail application stands dismissed or withdrawn.
Oblige.
This is already order was dictated. Then missed. Yes, we'll just yours will take some time.
Yes, I'll take. I'll take whole day.
Whole day.
Yes.
We'll take up item 28 first. Just for a minute. 28 will take up.
Please, Your Lordship.
Yes.
Lordship, this is a civil revision
Hmm.
filed by the dependent petitioners
Hmm.
agreed by the order passed by the Larness District Judge, Lupia, on 10/10/2022.
Hmm.
Whereby the petitioners will being restrained to continue or carrying on physical activities over the said
Hmm.
disputed land, that is Kallang footing area.
Hmm.
This is the case about it.
Where it is? Where is the
Page number 30, your lordship.
30?
30, your lordship. That is a conclusion part of the order. Paragraph 21. Impugn order passed by Lanet Civil Judge Senior Division, Jublia, on 20th/2/2022 is quashed and set aside. Consequent upon which Sri Poli Tatang, Sri Poli Tai, Sri Poli Tanian, Sri Poli Bharat, Sri Poli Tagara restrained to continue carrying on physical activity. These are the petitioners. There are 5 petitioners. There was a dispute regarding a boundary land between the 2 villages. Kusuk village, which belongs to the petitioners, and the respondent village is Pan village. Earlier, they were under the same circle, Mengyo circle. Later it was divided between 2 circles, one Silsanpo circle and one Mengyo.
What is this order? 28/02/2022?
They have respondent. They have filed one interlocutory application for temporary injunction.
Yes.
That order was being set aside, dismissed by the Learned Civil Justice Senior Division, which order they have challenged in appeal by the respondent. While before the district judge, Learned District Judge, UPI.
So why revision?
Due to this, your lordship, restraining the petitioners, they are not able to cultivate on their own land, your lordship.
It's okay. It's suit is pending.
The suit is pending.
Suit is
Before
pending.
Learned Senior Division Civil Judge.
So why is revision petition?
Due to the restraining of no further activities.
Why you have filed this revision petition?
Revision petition has been, your lordship, filed for.
You may be agreed by the order of
Agreed, yes, your
the.
lordship. We are agree
why-
because we are depending on that land, cultivation, room cultivation of.
No, this is something better to be decided. What's wrong in this order? Restraining you?
Restraining, due to restraining, your lordship, we.
Yes,
will
what's
not
wrong?
further continue our daily activities like cultivation, collecting woods, which we depend on the forest.
It's okay, but then what's wrong in this?
And moreover, this title suit filed by the respondent are taking time, your lordship. Still, the title suit is pending and in the stage of documentation issues.
Who has filed the suit?
Suit was filed by the respondent. They have filed the title suit.
They are plaintiff.
Plaintiff, where I am defendant. The pending title suit is pending, where title suit is pending at Planet Civil Judge Senior Division. Very interesting.
Just wait. There's no appeal provision against this order.
Here, Your Lordship, they have filed the title suit before the Lanet Civil Judge Senior Division, only making 5 parties, that is the respondents. At present case, the petitioners.
That will
And
be
they are-
the
they are-
issue in the trial.
They are claiming entire injunction. They have filed one mistake application for
But then they have decided to go for trial.
the case is on the trials, civil suit trial.
Yes.
And their injunction was been rejected, only that they have made, they are
Have you
claiming
filed
that
a written statement?
written statement, before the.
You are defendant.
We have not filed.
You are defendant.
Yes, Your Honor.
You file all these things before the civil judge, jurisdictional civil judge. What's wrong in this? Just because you will be deprived from cultivation, it's a dispute, totally dispute. The civil judge has decided to go for trial, and you have been given a chance to file written statement. You take all these grounds there, including non-joiner of parties. You show us any wrong here of this order. This wrong, since basically what the appellate court below has said is
Okay.
there's a provision left out. There's a provision scope of amendment of the plaint also.
Yes, sir.
Just because there are non-joiner of parties, and since the trial court, I mean the civil judge has decided to go for trial, all scopes are open.
Actually, they have, Your Lordship, filed a title suit, only making 5.
You take, that's
And
your,
they-
it's,
in their relief, they are claiming.
see,
And they are-
it's good for you, you do all those things before
Your
they,
Lordship, I will take few times to consult the petitioners.
because you are not able to show the jurisdictional error in this by the appellate court below. CRP is not like that, you are not, you don't have the ground to, I mean, file an appeal. You may be deprived, in fact,
Or else, Your Lordship, I'll take instruction from the petitioner, needs some time to discuss with.
if you have any other point to argue, only because of that, we cannot interfere just like that in the revisional jurisdiction.
Actually, Your Lordship, they are, I will take few times, Your Lordship. They have filed the title suit.
We understand.
Claiming the entire village of Kusum.
Yes.
But they may only ask 5%.
These are the things, it goes in your favor. I mean, there's a scope for you. You are not challenging the order of the jurisdictional court to go for trial. You are not challenging that.
The trial is pending.
It's pending. And then neither the suit has been dismissed for non-joiner parties or any other grounds. You are not challenging. You are not challenging the decision to go for trial.
Only we are challenging the order of the restraining the.
Restraining by the appellate court, first appellate court, by way of revision.
Yes,
It cannot be. Unless you some jurisdictional error or something like that, where this court can interpret. There's nothing. Only you are saying that the necessary parties, there's no misjoiner or non-joiner of necessary parties, right? And their injunction petition was rejected by a jurisdictional civil court, right?
Injunction petition of the respondent.
Yes, respondent, obviously,
Where I am dependent on them.
obviously. So that was appeal filed by the plaintiffs only.
Appeal was filed by the plaintiff.
Against the rejection of the
Rejection of
injunction.
injunction order.
Yeah.
After not getting their favor.
Unless you can show some wrong in this impugn order. I think we agree with this reasoning of learned first appellate court. Because he said, since the jurisdictional civil court has made out, admitted the suit for trial, if you are allowed to cultivate, it may change the nature and disfigure the land. Withdraw it. Approach, you file the appropriate, you file a written statement. And any other grounds you may take.
And withdraw your lordship and liberty if any ground to fight this if there is a plan.
In fact, it's not maintainable at all. Till revision petition.
What else, your lordship?
And Mr.
Given.
Withdraw or
I'll short time maybe given. I will consider once the petition.
yes, consult, withdraw it or else we will dismiss on merit. 5 minutes. Or 10 minutes.
For tomorrow, your lordship. Or else they are
Unnecessary
staying in
way,
a bed.
huh?
Only for today, your lordship. They are staying in village area, so in 5 minutes I might not communicate. So
List this matter on the prayer of Mr. Bhattacharya, A. Bhattacharya, learned counsel for the petitioners. List this matter on 06/08/2024 to obtain instruction. Please, sir.
Now, on the basis of that